Well, I'm pleased to be a part of this first panel discussion on federal preemption, and particular applications of the concepts of federal preemption to the Food, Drug, and Cosmetic Act and the Food and Drug Administration. For our discussion purposes, we'll focus on two recent Supreme Court decisions. One is Regal v. Medtronic, the other is Wyeth v. Levine. For purposes of our panel discussion, I'm joined by four individuals, each of whom will take on the role of either the plaintiff or the defendant in terms of discussing the facts, the issues, the holding, and open items as it relates to each of the cases. In particular, joining me on the panel to discuss Regal v. Medtronic, and we'll cover that case first to go in the chronological order, is Allison Ziva, public citizen, who will provide us with a perspective from the plaintiff's perspective on that case. And providing a perspective from the defendant's angle on Regal will be Ken Geller of Mayor Brown in Washington. Also on the panel are Rob Long of Covington and Burling in Washington, who will provide us with some perspective around the defendant's angle on the case in Wyeth v. Levine, and Elizabeth Cabraser from Leaf, Cabraser, Hyman, and Bernstein in San Francisco, who will give us some perspective from the plaintiffs. Before we launch into the panel discussion, however, I thought it made sense to step back and do a brief refresher on federal preemption so that we all sort of had a little bit of a memory jog on the terminology and how some of this stuff works before we dive into the deep depths of these two cases, and also talk a little bit about why these two cases in particular provide some fertile ground for discussion. So in terms of preemption basics, the concept of federal preemption is rooted in the Supremacy Clause of the U.S. Constitution. And simply stated, it's the power of federal law to trump state law in certain circumstances. Generally, analysis of federal preemption takes on one of two forms, either express preemption or implied preemption. Express preemption involves those situations where we're discerning the meaning of an explicit preemption provision, generally a statute or regulation. And a corresponding, at least recently, a corresponding focus on the text and the context for the statute or the textual language. Implied preemption, on the other hand, operates in the absence of an express statutory provision and itself takes on two variants. One is field preemption and the other is conflict preemption. Field preemption deals with the narrow range of situations where the federal regulatory scheme is so pervasive that it is presumed to occupy the entire field. So this would be a situation where a state passes a law and there's no federal law that sort of specifically conflicts with that state law, but the regulation, the federal regulation or federal statutory scheme surrounding that is so broad and deep that we presume that the federal regulation does preempt that state law even though there's not a specific conflicted point. Conflict preemption applies in two different situations as well. The first is a situation where it's actually impossible, sometimes described as physically impossible, for the private party to comply with both the state and federal law. The classic example of this kind of a situation is federal government passes a law saying that every car that General Motors manufactures has to be painted blue. The state of Michigan passes a law that says that every car that General Motors rolls off the factory line has to be painted red. Clearly, physically impossible for General Motors to comply with both laws, and in that example, the federal law would trump the state law, and there would be an instance of impossibility preemption. The other form of conflict preemption that we'll hear a lot about today, so I won't spend a lot of time dwelling on it, is the concept of obstacle preemption, which exists where state law stands as an obstacle to the accomplishment and execution of the full purposes and objectives of Congress or its appropriately designated regulatory agency. We'll hear a lot of these words thrown around, so I thought it was useful to step back and create that framework. In addition to sort of the different doctrinal methods that the court uses to analyze these questions, an underlying or subsidiary issue that you'll hear about is the appropriate level of deference to be paid to regulatory agencies and their thoughts on whether or not preemption exists or their regulations ought to be given preemptive effect. Why focus on these two cases in particular? Well, first of all, there are two very recent Supreme Court cases that deal with products liability and the issue of federal preemption. So they're quite timely and quite a lot of interest in terms of issues and legal issues that we're sort of seeing before courts. Second of all, Wyeth squarely deals with a pharmaceutical product, and since we're at a pharmaceutical symposium, it makes sense to talk about a pharmaceutical case. But beyond that, these two cases provide some fertile ground for, one, understanding federal preemptions as it's applied in a products liability case or applied in the pharmaceutical industry, but also creates an interesting construct for thinking about the policy or the economics behind this kind of regulation or this kind of a rule, because of some apparent similarities and some stark differences. In terms of similarities, both involve questions of state tort law imposing additional requirements on manufacturers, the pharmaceutical manufacturer, the medical device manufacturer, and whether or not those additional requirements imposed through state tort law claims should be preempted. Second, both involve the Food, Drug, and Cosmetic Act and the activities of the Food and Drug Administration. Now, this one in particular, if you step back and think about it from a public policy perspective or from an economic perspective, given the common backdrop behind the two cases, you would sort of always ask the question, does it make any sense whatsoever to get different results in these two cases? And I would postulate that it doesn't, despite the fact that, as you'll see very shortly, we do get different results. And finally, despite the fact that in the two different opinions, the courts invoke different doctrinal methods or pathways to get to an ultimate decision, both opinions spend a fair amount of time discussing the level of rigor or thought that the FDA gave to the particular requirement at issue. And I would offer for the consideration of the group that this reasoning or thoughtfulness of the FDA is a theme that we're going to continue to see in this type of litigation or these types of claims on a going forward basis. In terms of the differences, they are stark. Regal involves a medical device, Wyeth involves a pharmaceutical product. Regal is an express preemption case, Wyeth was an implied preemption case. Regal found in favor of preemption, Wyeth found against preemption. One last similarity, to call it that, is worth sort of mentioning at this point, and that is that we're likely not done with these issues, and that's why it becomes such an important part of our conversation. As it relates to Regal, Senator Ted Kennedy has introduced legislation in the Senate that called the Medical Devices Safety Act of 2009 that would seek to overturn the decision in Regal. And if he were successful in that endeavor, there is obviously the open question of what would that mean for purposes of future state tort claims involving medical devices. Also, interestingly, in Wyeth v. Levine, there are a pair of cases in the Third Circuit that were consolidated and docketed under the name Colachico that also involved a pharmaceutical product, also was an implied preemption case, just like Wyeth, but unlike the Supreme Court in Wyeth, the Third Circuit found that there was preemption in this instance. Those two cases have been sent all the way back down to the trial court level for further consideration in light of the Supreme Court's decision in Wyeth, and the question is, what will happen? Well, I think that there's an interesting potential set of facts that could unravel here, and that is that if you read the Third Circuit's opinion, there are substantial portions of that can be read as consistent with the Wyeth decision at the Supreme Court level. The Wyeth decision found no preemption. The Third Circuit opinion found that there was preemption. The difference is the issue turns on how much consideration or how thoughtful was the consideration that the FDA gave to the particular requirement at issue. In the Third Circuit case, the court was persuaded that there was a lot of consideration given to the requirement at issue, and as a result, what the plaintiffs were seeking through state tort law was in fact preempted because the FDA spoke very clearly on the issue. You had a sort of inverse analysis that occurred at the Supreme Court level. And so even though someone could run around and say Wyeth is the definitive case saying no preemption as it relates to pharmaceutical products under the Food, Drug, and Cosmetic Act, I would proffer that we're not quite yet done with that. With that brief introduction, I will now turn it over to our panelists, and we will start with Alison Ziva, Public Citizen.